Okay, we're here with Stark County Commissioner Comr Bernabei, and occasion is a meeting this morning between the commissioners and George Maier and his attorneys on the matter of the lawsuit pending in the Ohio Supreme Court as to whether or not George Maier is qualified to be Stark County Sheriff, a suit having been filed by former Sheriff Tim Swanson in the Supreme Court. So Stark County Political Report unfortunately couldn't make it this morning because of an intervening event. So Commissioner Bernabei has agreed to go on camera and to recount for the viewers / listeners, readers of the Stark County Political Report what happened this morning at this meeting. Commissioner Bernabei.
We had a special meeting scheduled today at 11 a.m. The agenda was to discuss and consider appointment of counsel for Sheriff George Maier. We had a second item on that agenda, and that concerned the potential for an executive session to discuss pending or imminent litigation, which would have encompassed this case. At today's meeting, all three commissioners were present, along with Mike Hankey. Sheriff George Maier was here with two attorneys from the law firm of Retzel and Andrus that is representing him in this lawsuit. Thomas Rosenberg, and I believe it was Mike Travern, although I did not obtain a card from him. Also present then were Prosecutor John Ferrero and Chief of the Civil Division Ross Rhodes. I think that the first thing that occurred in today's meeting was that I did ask, the prosecutor whether or not he desired or needed to have an executive session with the board, to discuss this matter. He indicated that he thought that everything that we needed to discuss, could be held in open meetings. So the meeting was an open meeting through its entirety. The main topic, or the only topic for the meeting, was again the request by the prosecutor for the board to, in conjunction with the prosecutor, to appoint counsel for George Maier in the subject lawsuit that you mentioned in your introduction. That is the Ohio Supreme Court case, which is challenging his qualifications by statute to be sheriff. On last Wednesday, we did have an executive session with Civil Chief Ross Rhodes. Part of that executive session really covered the same kind of things that we're going to talk about that happened in open session today. He did provide to us a proposed motion so that we understood exactly what the parameters were of the topic last Wednesday, and again we looked at that today. So one of the things was that we read this into the record, and it is a request by Prosecuting Attorney John Ferrero and the Board of Commissioners making application to the court pursuant to Revised Code 305.14 to make a joint application to the Common Pleas Court for permission to allow the Board of Commissioners to appoint legal counsel for Sheriff George Maier to represent him in the Supreme Court case due to the prosecutor's conflict of interest in the case. There was no discussion about the conflict of interest because that issue has already been previously discussed. We talked about fees and what they might be and where we should go with this matter. Mr. Rosenberg, on behalf of the sheriff, discussed the case and discussed what work they had already done on the case. He clarified that the work that they have done on the case, and they have done a lot of work preliminary to George Maier being appointed by way of rendering a legal opinion on his behalf with regard to his qualifications and some other work. He indicated that any work that had been done before George Maier became sheriff by virtue of his appointment was not going to be billed to the county. He indicated that they had expended a lot of hours already in this case and were not billing the county, and they had expended their learning curve time prior to his being appointed. He was asked how much to this date and time he believes their fees were after George was appointed, and he indicated that he believed that it was probably $3,000 at tops. That included several motions which have been filed and probably some other conversations and internal research and work. We discussed hourly rates. One of the subjects that I had asked Mike Hankey to research for me was the hourly rate that was approved by the Court of Common Pleas in the Ziegler litigation. That's the last time That's the only time since I've been commissioner that we paid attorney fees, and those were paid upon application to the court. Those were approved by the court at $210 an hour just to create the parameters for the discussion. Mr. Rosenberg, again, he's the senior attorney. He is an attorney in Columbus as well as the other attorney is an attorney in Columbus. So they are close to the court, and they apparently work in the court frequently. He indicated that they were willing to proffer a cap to their attorney fees in this case, and he proffered the cap. He believes this case will be relatively simple and straightforward to litigate in the Supreme Court. Again, this case could take anywhere from 40 days to 9 to 10 months, as the Ziegler case did. He anticipates that most of the work will be based upon the filing of briefs and so forth. He believes that the issues are relatively simple, at least from their perspective. And he proffered a cap of $20,000 in fees, subject to the condition that if circumstances, particularly outside of his control, and that would be extraordinary discovery demands or other things generated by the other side in this case would drive their attorney fees up, he was clearly willing to agree to a $20,000 cap. That being said, there was further conversation about it. We entertained a motion to amend this motion to approve it, but to amend it, and the amendment would be, instead of appointing legal counsel for Sheriff George Maier, the entry will now read specifically, it will appoint the law firm of Rutzel and Andrus to appoint Sheriff George Maier in this case in an amount not to exceed $20,000, subject to an application, if extraordinary circumstances do occur, to come back and ask for additional attorney fees. That request would probably go to the Court of Common Pleas and not to the commissioners, I would anticipate. The motion was made and seconded, and the entry then was approved. So as of right now, and this is just a few minutes after 1 o'clock on Tuesday afternoon, we are waiting for the prosecutor to provide us an entry adopted pursuant to the language of the motion, and that will then be signed off on and sent to the Court of Common Pleas for approval.
If I understood you correctly, in the estimate on the timeline, could be as long as 9 months before we being Stark Countyans, know if Sheriff Maier is qualified by statute to be sheriff?
Yes, it could actually be longer. I mean, the Supreme Court, there is no rule with regard to any time frames that they have to decide a case like this in. They are the final stop on this. There are no appeals from the Supreme Court. There should be no lower court action either in this case. But the 9 months is just an estimate based upon the time that it took the court in the Ziegler case. It was approximately 9 months from filing to decision.
But if I understood correctly, it could be shorter than that, maybe 4 months?
It could be shorter than that,
okay.
Yes.
So nobody really knows.
No one really knows.
Right.
I think that the 40 days was used, not 4 months, by using 40 days, I think, or that was discussed, simply because there are pleadings that have to be filed, and I think that there are some early time limits, that the court couldn't decide the case earlier than those time limits, but once you reach, the basic filings in this case, the case could be ripe for decision at any time, depending on the court's docket and other issues.
Thank you, Commissioner Bernabei.
Thank you.